Thanks. All right. First case that remains on the docket is Garcia versus Avatar Property, 19 CA 4465. Who's here for the plaintiff?
After the plaintiff, on the happy of plaintiff, Your Honor.
All right. And this is Mr. Kane, correct?
Correct, Your Honor.
All right. And who's here for defendant?
Derek Goldstein up on behalf of Avatar.
All right. This is plaintiff's motion to overrule defendant's objections to requests for production, which seem primarily, primarily to be focused on work product with regard to the claims file, if I'm correct. But Mr. Kane, go ahead. It's your motion.
Yes, Your Honor. There's actually, I've narrowed it down to primarily two requests. The first request is number 2. I'm requesting the underwriting file for the plaintiff's policy of insurance. Really what I'm looking for are the photographs and any report showing the condition of the property at the time that the insurance was purchased. The insurance was purchased in 2016. This is a 2017 Hurricane Irma loss. As one of their defenses, their fourth affirmative defense, they've alleged the damages were caused as a result of wear and tear, faulty, inadequate, or defective maintenance. So I want to see what Avatar saw was the condition of the property only a year before the storm. So I'm requesting, as part of that, any photos they have and any reports they have showing the condition of the property when they first insured it. And on that particular one, they've made a relevance objection.
All right. And what's your other issue?
The other one is number 12, requesting the photographs of the field adjuster. They've listed their field adjuster as a witness in this case. He came out and was the one who initially inspected the property. There is no basis to object to these photographs. There's a case, actually, Avatar is the defendant. It's Avatar versus Simmons. That is 298 Southern 3rd, 1252. In that particular case, the court had ordered the production of the field adjuster's photographs because it basically held there is just no wholesale claim file privilege, and the defendant really did nothing to prove that these photographs were in fact work product and compelled the production of them.
All right. So response.
First, Your Honor, good morning to the underwriting. While our defense is that the damages...
Well, I'm not going to order production of the entire underwriting file. I'm only addressing specific requests that Mr. Kane mentioned. Go ahead.
Okay. I'm not certain that... Later on, I don't know that there is any photographs or even reports in the underwriting file.
Okay, but that's not the issue. Okay. The issue is, why would you not produce them if you have them?
Well, and Your Honor, the relevance of the underwriting, our defense is due to wear and tear and improper installation. It's not based on prior existing damage prior to the storm. It's based on 2 years later when they're saying this damage is from Irma. We're saying it's from wear and tear. I'm not necessarily saying that it's done before Irma. That's why we sort of objected on the relevance, because the defense isn't necessarily based on the damages existing at the time of Irma, but that they're not from Irma, they're from wear and tear due to time and age. So that's why we objected there. As for the field adjuster, we had already agreed to give over the field adjuster photographs prior to his deposition, but plaintiff's counsel wanted the entire report prior to the deposition. That's where we objected. So the photographs for the field adjuster, we have no problem producing. We will do so today. But as far as the underwriting, I don't know if there's anything in there, first. And second, even if it is, our defenses are based on the damage not being from Hurricane Irma, not specifically saying they were.
I got it the first time you said it. All right, Mr. Kane, what's your response?
Judge, this is the first time hearing. This is a home that was built in 2016. So I really, if they've got photographs and reports, I'm entitled to see them. If they're going to come up and argue wear and tear, I've not heard this position before, that it was from the time of Hurricane Irma to the time they inspected. But either way, it's relevant.
Okay.
To be able to see the
so I'm going to grant your motion, Mr. Kane, as to the specifics that you've requested. So I will grant it with regard to the photos and the report of the adjuster that went out and did the inspection. And just the report, though, not the whole file, just the report, if he made a report. And secondly, I will grant it with regard to the photos and any report or whatever from the instigation of the insurance. All right.
Very good. Okay,
so I'll need an order. I'll need an order from you, Mr. Kane, after you've circulated it forward to my my office email address in Word format, please.
Very good. Thank you, Judge.
All right. Thank you, counsel. Oh, you guys are set for trial, by the way, in July. So
I thought it was the August setting, Judge. I think we have calendar call in July I thought the order said August.
Oh, yeah, you're right. You're right. That's when the pre-trial is. All right.
We'll be ready to go.
All right. Good enough.
Thank you,
All
Judge.
right. Next case is Webb Roofing versus Castle Key, 19 CA 2632. Another motion to withdraw.
Yes, Judge. Good morning, Judge. Steve Carestes on behalf of the plaintiff. It's the same motion to withdraw we filed in all these Webb cases. Sorry we didn't get it on the same day.
That's okay. So it looks like you properly noticed. So that's usually the only thing that the court's concerned about. And again, is there anybody here on defense side?
Yes, Your Honor. This is Michaela Kern on behalf of Castle Key Indemnity.
Okay. The only thing that really the court can do here is just make sure that, number one, there's language in the order that reflects that if they don't get representation, that they're going to ostensibly be pro se, but they can't be because they're an entity. So that language needs to be included. I also need an address set forth for the plaintiff in the order. And then I'll give them 30 days to get an attorney. So that's as much as I can do. If you've got stuff scheduled within this 30-day time period, and it's 30 days from today, so not 30 days from whenever the order's entered. But if you've got things scheduled, you're going to have to probably postpone them to another time. All right?
Sounds good, Judge.
Yes, Your Honor.
Thank you.
Thank you.
All right, next is Forsyth versus McNabb et al. 21 CA 669. Who's here for the plaintiff?
Good morning, Your Honor. James Chillamy on behalf of Robert Forsyth.
All right, is anybody here for defendant? This is a default hearing. So the only thing I'll mention is that technically speaking, even in these default situations, you're required to set these final hearings by order in not less than 30 days. But as a practical matter, it's too hard to get you guys to do that. So if nobody shows up to object, I proceed on the notice. So if you're willing to do that, that's fine with me.
I'm willing to proceed, Your Honor.
All right. So you filed a motion for a final judgment on default. Anything you want to tell me about that? It's pretty self-explanatory.
Yes, Your Honor. There's just been a clerk's default entered against 3 of the named defendants, of which we're seeking a motion for final judgment at this time.
All right. So this is a, hold on. Here it is. This was a cause of action because the plaintiff, as I understood it, gave some folks a vehicle to fix, and after several years, it was not fixed, despite the fact that they'd give them a bunch of money. Am I correct about that?
It was 2 different vehicles, Your Honor. It was a Corvette and a Trans Am, 2 very classic cars, 2 very expensive cars, of which there has been rife damage to both cars, one of which is now in the plaintiff's possession. Parts were sold. New parts were put on that weren't requested.
Yeah, got it. Anyways, but what I didn't see, I don't think was, did I see affidavits in this file or not? Oh, yes.
There was an affidavit. Yeah, there was an affidavit in this file.
All right. All right, so your motion's granted. Forward me a final judgment to my office email address in Word format, please.
Sounds good, Your Honor. Thank you.
Thank you. All right. Next is Epstein. This is a probate case, 21 CPU 1033. Hold on just a second. This is with regard to a summary administration that I didn't grant. So who's here for that case?
It's Jennifer Orcadanges, Your Honor.
All right, hold on, let me just pull this up. All right. So I denied the admission of the will to probate because I had some concerns about this. The will that was filed in the court file had been executed while the petitioner was still married to the deceased, but he's not now married to her, or he wasn't at the date of death. There's adult children who might inherit if the petitioner is not entitled, and there wasn't any evidence that everybody had been given formal notice or any type of notice of this proceeding. So that, I mean, all those other things may or may not be legally relevant because there may be other circumstances that obviate them, but the notice issue is the concern for the court.
Yes, Your Honor. I understand that. And I didn't so much need a hearing this morning as I did to just bring to your attention. What I failed to put in the petition was that the decedent and petitioner actually divorced 5 years prior to the will execution. So in 2015, they were divorced. And then in November of 2020 was when the will was actually executed. So they were not married at the time that the will was executed. The decedent did name him, Mr. Epstein, as the personal representative and also named him as the sole beneficiary. But she did that 5 years after the marriage actually was dissolved.
Still need to have notice to these children.
Okay, Your Honor. If I may just, the Florida statutes and the probate code do govern the contents of a notice of administration document, and the identity of the parties entitled to a copy for notice are beneficiaries.
I mean, for one thing, how do I know this is the most recent will? I mean, this is just a suspicious situation, and I'm not signing off on it until you've crossed every T and dotted every I.
Okay,
So,
understood.
And that may require that you amend your petition, but I'm not signing off on this. This is very suspicious, and maybe it may be perfectly fine, but I don't know that, and all I can look at is the file.
Okay,
right?
I understand. Yes, Your Honor.
All right, thank you.
Thank you.
So Kathy, the rehearing is denied, but you can just reflect that counsel's going to address the court's issues.
Thank you.
All right, thank you. All right, this is Burrell versus Wiley Thomas, 20 CA 2776. Who's here for the plaintiff? Anybody? How about defendant?
Laura Johnson's here for Thomas Wiley. Laura Johnson.
Okay. Anybody
Good morning,
here?
Judge.
Good morning. Anybody here for plaintiff? This is defendant's motion to show cause and for sanctions to strike plaintiff's pleadings. You seem to be having some difficulty with the plaintiff.
A lot, Your Honor. We did enter the order to get discovery back in January. We didn't receive any discovery till March. And the only discovery we received was basically a copy of the documents produced to Progressive. We still haven't received a verified interrogatory, any responses to our admissions or admissions with interrogatories. I've tried to contact them numerous times since March, just with no response at this point. So
is there still an attorney? Is there an attorney on this case?
Yeah, David Crockett over at Morgan Morgan is the plaintiff's attorney.
All right, well, you know, the problem here is that, let me just take a look at this. Hold on.
We've had to reschedule the deposition already once based upon, just their negligence in getting these documents over to us. We've got another one set in mid-May that we're probably going to have to reschedule again, and we've already got mediation set in June. And I mean, it's been 6 months at this point, so.
Okay, well, normally I would not strike pleadings at this point, because my interpretation of the case law in terms of striking pleadings is that it takes more than two sort of non-compliances for it to pass appellate muster. But in this particular situation, where we don't even have the plaintiff's attorneys showing up, as well as all the other issues that you've set forth in your motion argued here, I am going to grant your motion, and I'm going to, as a sanction, strike the plaintiff's pleadings, which will, of course, effectively dismiss the case. So you'll need to send me an order. Now, that dismisses the case without prejudice, just so you know.
Yes.
You'll need to send me an order to my office email address in Word format, please.
Will do.
And
Thank you so much,
it needs to recite all of these bases. All right?
Okay. You got it.
Thank you.
All right. Thank you so much, Judge.
All right. Next case is James and Patricia Dolan versus Continental Construction, 20 CA 1842. Who's here for the plaintiff? Anybody?
Good morning, Your Honor. Ryan Murphy on behalf of James and Patricia Dolan.
All right, and anybody here for defendant?
Yes, Your Honor. Matthew Buttrick and Danelle Hicks on behalf of Continental Construction.
All right, this is a motion to stay. My only actual concern about it was you didn't tell me how long, but maybe somebody has some objections. So whose motion is this? I've forgotten.
Your Honor, it's the defendant's motion.
All right, go ahead.
Your Honor, I thought 2 minutes of background might be helpful since this is the first hearing in the case. This action concerns the construction of a 15,000 square foot residence on the private portion of Keewaydin Island. The house is right on the beach. It's only accessible by boat. Plaintiffs, James and Patricia Dolan, are the equitable owners of that residence. And
how many square feet?
15,000.
Wow.
Exactly.
On the private end of Keewaydin. Well, that's unfortunate for Keewaydin, but go ahead.
Exactly. Your Honor, defendant Continental Construction, my client, was the general contractor. The construction work began in early 2007, and it was completed in June 2010. The recession hit in the middle of that period, and the Dolans issued a stop work order on the job. That came at a critical time because the exterior stucco had just been applied, but it had not yet been sealed. The stucco ended up being exposed to the elements for more than 9 months before the stop work order was lifted, and the work was able to resume. Fast forward a few years, in about 2015, 5 years after the house was completed, Mr. Dolan began complaining that his stucco was cracking. He claimed it was defective and asked my client to have the stucco sub come out and take a look. My client and the sub did that on 2 occasions, advised Mr. Dolan it wasn't defective, but the stucco did need maintenance and resealing like any stucco would, particularly stucco that's in a beachfront location and had been exposed to the elements for an extended period of time before it was first sealed. The sub gave the Dolans a quote for the maintenance and resealing work that needed to be done, but the Dolans didn't do it. That led to a worsening of the condition. And finally, in early 2020, last year, the Dolans served a notice of construction defects under Florida statutes, chapter 558. That notice alleged 2, quote, latent defects, one being that the stucco was cracking and the other being that water was getting in to the edge of one of the exterior decks and somehow getting to the ceiling in the patio below. The parties went through the 558 process at that time, which involves inspections, discussions, document production, et cetera, but they weren't able to reach agreement as to the alleged defects. The Dolans then filed their initial complaint in this action, but they actually didn't serve it for 5 months. My client had no idea it had been sued until November of 2020. Worse, during that period, the Dolans performed extensive demolition and destructive testing on the areas of the house that are at issue in the case without notice to us or an opportunity to preserve evidence. The Dolans' current counsel, just to be clear, wasn't involved at that time. They were substituted in shortly before the initial complaint was served in November. The Dolans' new counsel then filed an amended complaint which alleged a host of new latent defects. And that's, Your Honor, what ultimately prompted our motion to stay. And so I don't know how much Your Honor has dealt with the Chapter 558 process, but it is a mandatory process that involves a pre-suit notice of, quote, each alleged construction defect.
I understand that, but my question is, though, how long of a stay do you need?
So, Your Honor, unfortunately, we can't control when the plaintiffs comply. And the issue here, Your Honor,
you know, give me like a ballpark. Okay,
I'm sorry.
I understand all that, but I'm not, and I agree that it's appropriate under the statute. But I'm not going to just stay a case indefinitely. So if I have to stay it, if you're not going to give me a time frame, then I'm going to just make one up. And if you need more time, you'll have to come in and get it.
I understand completely, Your Honor. And the real issue is that since the time that the plaintiff filed their amended notice of construction defect, which was in December, late last month, the Dolans' counsel sent me an email advising that he plans to amend the allegations of defect again to correct certain inaccurate allegations and modify others. He didn't say which others or how he plans to modify them, just that he plans to do it. And we asked him to promptly get us those amended allegations so that we could evaluate whether we need additional inspections, how much time it would need. but we haven't received anything in the 4 weeks since that time. So, Your Honor, I would suggest there are two options. One would be to issue a stay for 60 days, and hopefully we will be able to resolve these issues within that 60-day period. The other option, of course, would be to simply, exercise your inherent authority to dismiss it without prejudice, with a direction that it can't be refiled until the plaintiffs finalize their allegations of construction defect, comply with the pre-suit notice requirements under 558, which are mandatory, and then fulfill their other obligations under Chapter 558.
So ballpark time is how long?
I think, Your Honor, 60 days would be appropriate at this point, and hopefully the plaintiffs can finalize their allegations within that period, and we can conduct any additional inspections that need to be done.
Okay. All right. So, Mr. Murphy?
Yeah, Your Honor, unsurprisingly, I completely disagree with the version of the facts that was set forth before you. I would like to note that the dismissal with prejudice to refile would be an extraordinary measure, and it's just an attempt to put us outside.
I'm not gonna dismiss your case.
But the reality is, the only question before Your Honor is whether or not the plaintiffs have complied with the 558 process. There was an initial 558 notice given in 2020. In May of 2020, they had a full inspection of the property. I filed an amended complaint, conceitedly, that offered more detail of the construction defects. I informed Mr. Buttrick that he'd have the opportunity to inspect. I provided him a second 558 notice the day after I filed the complaint, which went through extraordinary detail of the stucco defects at issue in this litigation. February 1st, they had a full inspection of the property. Experts, attorneys, subcontractors, the entire property was there. I was present and pointed Mr. Buttrick and those in his accompaniment to every single defect that we had at the property. That inspection occurred. I offered Mr. Buttrick an extension to respond to the 558 notice, and that was granted. During the process, we've exchanged over 10,000 documents under the 558 process. Fast forward to March 18th. My experts were undertaking destructive testing at the property. I offered to Mr. Buttrick's client the opportunity to have his experts there, document every piece of evidence that you'd like, and observe my experts' testing of the construction defects. That occurred. Everyone was present on the property. And then as recently as last week, March 23rd, my client wants to proceed with corrective work. His house has extensive construction defects, and he'll be doing corrective work over the next 2 years. And I've apprised Mr. Buttrick of the fact that he has the right to see demolition. On April 23rd, we started demolition. Once again, full access to the property and a bunch of representatives there, including experts. So we have now had 4 inspections of this property under the 558 process. I have offered Mr. Buttrick in every single email full access to the property. I welcome him to come and conduct any destructive testing that he wants. He can document any evidence that he wants. But here's the reality. They're asking for a 60-day stay. Mm-hmm. Well, it's been 130 days since this motion was filed. I agree there should have been a stay in the beginning, pending everything that my client has done for Mr. Buttrick's client. We have completely complied. And if you look at the statute, it is not mandatory. And in my response, I've cited the Supreme Court. And the Supreme Court says that the 558 process simply encourages settlement by providing a procedure to lead the parties to the waters of compromise. Quote, it does not make them drink. 4 inspections, destructive testing. I think it's very clear that the waters of compromise have not been found. So it's time that we now proceed to the litigation process and have the trier of fact make a determination on, hey, are these defects attributable to Continental? That's the question in the case. So
let me ask a question from, where am I? Defendant's counsel. Why did you wait so long to set your motion to stay?
Your Honor, we actually didn't set the motion. When this motion was originally filed, Mr. Murphy did not contest it. He conceded it was valid. And Your Honor,
well, okay, but Mr. Buttrick, then the correct thing to do is to do a stipulation in an order Okay, so I mean, here we are. He's correct. I mean, why should I give you another 60 days when you've ostensibly had since December 14th?
Your Honor, if I could put up on the screen here the email that Mr. Murphy has neglected to mention. Last month, on March 30th, he advised there will likely be an amendment coming to further clarify the defects. The purpose of the 558 pre-suit process is so that the defendant knows what the plaintiffs are alleging, so that the inspections can be done with the knowledge of what is being alleged against them.
Okay, so what you're saying is that the motion to stay is somewhat irrelevant because now there's other stuff that you didn't even know about.
Yes, Your Honor. And I don't want to be in a situation where we start the litigation, they file their amendment, and then we have to be back here with another motion to stay.
Your Honor, if I may address this.
Yep. Go ahead.
First of all, there's no amendment before Your Honor. Now.
Secondly, this is not an evidentiary hearing, actually.
There's no amendment before Your Honor. The email was simply to state there was one defect that we're completely removing upon investigation, and further clarification is it's not going to change the defect. The stucco is falling off the building.
Okay, well, I am gonna grant the motion to stay for 60 days beginning today. So regardless of when you guys get me the order, the first day starts, you start counting tomorrow. And we'll see where we are. Because, I mean, again, there's ways of handling these things. Again, this is not an evidentiary hearing, so I can't really determine who's more at fault than the other. But nevertheless, we're gonna give it 60 days and that's it. And then we'll proceed along. I don't know that you all have, we do have an order setting pretrial conference in 2022. That's when your trial is in 2022, September of 2022. So I don't think this is going to delay it that much. All right, I'll need an order from you, Mr. Buttrick, sent to my office email address in Word format after you've circulated it to opposing counsel.
Very good, Your Honor. Thank you.
And I'm not striking anybody's pleadings at this point. All right.
We didn't ask for that, Your Honor.
Okay, just in case that wasn't clear.
Thank you, Your Honor.
All right, thank you.
Your Honor.
Your Honor, real quick, I just want to see if Magic Construction versus Heritage is on your docket for today. Me and counsel worked on it.
No, it's not.
All right, thank you, Your Honor.
Yep. All right, next is Cocoa Bay Condominium versus American Coastal, 21 CA 348. Who's here for the plaintiff?
Kelly Kubiak on behalf of the plaintiff.
And who's here for defendant?
Good morning, Your Honor. Elon Cantron, Burke, Merchant, and Sims on behalf of defendant.
All right, so there appears to be two things set for hearing today. One is a petition to compel appraisal, which is count 1 of the complaint. And the other is a motion for a case management conference. I'm not really sure.
Your Honor, the petition to compel appraisal was taken off by the parties' agreement, and the case management conference was set so we could discuss setting the petition to compel appraisal. It's defendant's position that the petition to compel appraisal will require an evidentiary hearing due to the fact that defendant has raised non-compliance with post-clause conditions as an affirmative defense.
Well, you know, the problem here is I don't really like proceeding on counts to a complaint in the form of a motion. Usually I do occasionally get them as a part of a complaint, but usually I get them in the form of a motion. You have in your complaint, hold on. Did you ask for a jury trial? Yes, you did. So really you asked to have that issue tried by a jury. So how am I going to be proceeding on it as a part of the complaint?
I will say this, that after we saw the defense's response to the complaint, noting that there were several documents they did not receive, we filed a motion to abate yesterday to provide those documents, which we have, but I believe that they want to do a follow-up examination under oath of that witness. And I don't want to speak out of turn for Mr. Contro, but I think the proper thing right now is actually a motion to abate. But
I'm not abating your case so you guys can get your act together. You want an appraisal though, is that correct? Yes. I'll abate for an appraisal, but I'm not abating so you can just do discovery.
Okay.
So what is it you want me to do?
Well, Your Honor, we're here today to get a hearing on the petition to compel appraisal. Your Honor is absolutely correct.
Ms. Kubiak, is there an objection to the appraisal process that was likely in your?
Yes, Your Honor, we do object.
Yeah, well, let's let Ms. Kubiak tell me.
I know that the defense objects. They have two objections to the appraisal. One of them is failure to receive certain documents, and I think they want a follow-up examination under oath. We've now provided those documents as of yesterday. They were inadvertently not given to the defense. We also have no objection to giving them a follow-up EUO regarding that. And then there's no reason not to proceed to appraisal. I understand they did give coverage in the beginning. They made a payment of $100,000. They since now took the position that it's overinflated. The case law is clear in the second DCA where there was coverage afforded initially, even if they later on say that there's fraud, that still proceeds to appraisal.
Okay, but so Mr. Contra, what's your objection to the appraisal?
Your Honor, first, the claim was denied in entirety. Second, the breach of post-loss conditions was knowing and intentional. We specifically requested certain reports on which the plaintiff was basing its claim for over $4 million to replace windows and sliding glass doors. We took the 3 different sessions of the EUO plaintiff's glazing expert and each time requested his reports. At those times, it was the plaintiff's position that we were not entitled to those reports. They would not provide them. We requested them again in writing multiple times. They chose not to provide them. We then actively requested those, confirmed them on the record with those requests during the insured EUO. They said they would not provide the
okay, well, here's what we need to do. Number one, somebody needs to set this up in a motion as opposed to in the pleading. Otherwise, I can't address it as a part of the case because you've asked for a jury trial on it. Number one. Number two, it does need to be an evidentiary proceeding, though I think it's a giant waste of attorney fee time, but nevertheless, your choice. But I will tell you, there's very few instances where I have not ordered an appraisal. Now, this may be one of them. I don't know. I haven't heard the evidence yet. But the courts have given us very wide leeway in enforcing this policy provision, even in cases where ostensibly there's been a denial of coverage for various reasons. So again, I don't know exactly why coverage was denied here, but part of what occasionally the courts can order is an appraisal requiring the appraisers to delineate the cause of various damage so that when we then get it back and have to set it up for a jury trial, we can figure out whether or not it actually is covered. We can reserve those issues for the court to decide or a jury to decide. So again, not precluded just because coverage is denied, but it sort of depends on why coverage was denied. So A, somebody needs to file a motion. B, it has to be an evidentiary proceeding. You'll have to figure out how long you need and contact my office for that. But it's not going to be soon, unfortunately. I mean, it's not going to be next week because you'll probably want, an hour or so, I would imagine.
Yes, sir.
Okay, so you do not have a pretrial date, so that's a good thing. You do have a case management conference coming up in May. I will email my case manager now and tell her to take you guys off that, because I think we're a little premature at this point. Hold on just a second. Good news is you're a 2021 case, so all right, so that's who's going to do an order from this proceeding today?
I can do the order. Oh,
okay. So again, we had a partial case management conference today. You got to file a motion with regard to the appraisal, whoever wants it. And we need to have an evidentiary proceeding on that with regard to whether or not the court should enforce the appraisal provision of the policy.
Should the order also note that we're taking off the case management conference in May?
Sure, that's fine.
Thank you.
I did email my case manager, but that's a good idea. All right, thank you.
Thank you.
Thank you.
All right, next case is Naples Community Hospital versus Travel Insurance et al. 18 CA 2546. Who's here for the plaintiff?
Good morning, Your Honor.
Also, Your Honor.
I have got more than one person for the plaintiff?
No, Tim Hartley for the plaintiff, Your Honor.
Okay. And for travel insurance facilities?
Yes, Your Honor. Stephen Marassi on behalf of Travel Insurance Facilities and Mrs. Hutchinson.
All right. Do we have anybody else that's appearing in this case for the defendants?
No,
Kelly Boyd, the court reporter, is also here.
All right. Thanks very much. All right. So this is plaintiff's motion for sanctions. Go ahead, Mr. Hartley.
Thank you, ma'am. I don't bring these motions lightly. I don't like bringing motions for sanctions, but this is a case that unfortunately cries out for that. The court may recall that this is a claim made by Naples community against a bunch of insured patients who traveled from overseas.
Mm-hmm.
Those individuals is Vivian Hutchinson, who was here from the UK back in 2018.
Mm-hmm.
And we obtained service on Ms. Hutchinson through the Hague Convention back in late 2018. There's an affidavit of service in the file about that. She then, through her counsel, filed a response to the complaint, motion to dismiss for a variety of reasons, but none of which was that there was insufficient service on her. So the case proceeded. There was a hearing in July of 2019 denying in part the motion to dismiss. 2 years later, she files a motion claiming that there was insufficient service on her. We responded to that motion and in part advised opposing counsel in the court that it should be denied because there's no sworn statement contesting service on Ms. Hutchinson. Shortly thereafter, there's an amended motion to defeat service where she now attaches a declaration in which she states under penalty of perjury that she was never served with this lawsuit. Not that she didn't recall whether or not she was served, not that there's a question of whether or not she was served, but she stated under penalty of perjury she was not served. So we contacted opposing counsel. We said, we'd like to take her deposition. We'd like to test the veracity of this declaration, and they refused. They said that we could depose her on written questions, which frankly is useless. I mean, we all know that those questions.
Well, I've been part of this, so yeah,
Okay,
I remember this. Yeah.
Yep. Man, the issue today is very simple. You know, is a declaration stating affirmatively under penalty of perjury, I was not served, the same thing as a sworn deposition statement where she says, after extensive questioning, I have no idea what happened on the day that I was allegedly served.
Okay, well, let me just tell you what my concern was in reading your motion, and perhaps you can address it,
Yes,
which is it looks as though, and maybe I missed it, and I don't know that I had the full transcript, but I'm looking at the parts that are set forth in your motion. But you clearly inquired of her as to her memory on that date, but you did not say, do you recall? I mean, what you did not ask her was, on that date, or at the time that you completed the declaration, did you remember what happened on that date? You asked, now, do you remember what happened? And she clearly says, no, I don't remember anything. But, and you didn't inquire as to whether or not she might have any physical or mental reasons for not remembering that I saw.
Well,
and again, perhaps I missed it, but that was my concern, because as you know, striking pleadings is kind of a difficult, and it's an emergent request for relief, and so we don't do this very often unless it's very clear.
As to your first question, Your Honor, yes, I did not ask her whether on the date that she signed the declaration, if she recalled whether or not she had been served.
Mm-hmm.
That states very clearly that she was not served. What I did ask her was her recollection of the events of October 5, 2018.
Mm-hmm.
But at the outset of the deposition, and I have filed the transcript in its entirety in the court, I very thoroughly asked her whether or not she was under any medical condition or taking any medications or anything that would affect her memory of any of the events on October 5, 2018.
Okay.
So, you know, at the end of the day, what we're asking the court to do is to enter sanctions against Ms. Hutchinson, and really, Your Honor, in fairness to Ms. Hutchinson, against her insurance company, because I doubt that Ms. Hutchinson came up with the idea of filing a declaration stating that she wasn't served 2.5 years after the date she was served. We're looking at a case where there's $101,000 that's owed for a medical bill.
Well, I can't really enter it against the insurance company unless you have evidence in the transcript that says, you know, that Ms. Hutchinson was called by the insurance company and they induced her to lie. I mean, is that in the transcript?
No, but and let me restate that. It is the position of NCH that the actions of this individual, Vivia Hutchinson, fall afoul of her requirement to be fair and candid with the court. Stated under oath, under penalty of perjury, that she was not served. She stated in her declaration, in her deposition, under oath, after extensive questioning, that she had no idea whether or not she was served. Those two statements are diametrically opposed to each other. One is a lie. We don't know which one. But either way, there's a lie that has taken place in connection with this particular motion.
All right, Mr. Maracia.
Yes, good morning, Your Honor.
I'm sorry, let me go back. Mr. Hartley said, what you're asking me to do is strike Ms. Hutchinson's pleadings or responses?
Strike her pleadings or alternatively enter sanctions for the time and expense involved in the presentation of this motion, taking her deposition, filing the motion to compel her deposition, and related actions.
And sanctions against her, meaning that she pays this, right?
Right. Yes, ma'am.
Which, because, you know, there's such a great history here of her paying with this. I mean, you're suing her basically for non-payment. So I don't know what that's going to do, but go ahead, Mr. Maracia.
Yes, good morning, Your Honor. For starters, Ms. Hutchinson is nearly 80 years old, and she testified that she's currently suffering from medical conditions, several of them, and so there's no deliberate or willful.
Okay, but are they medical conditions that actually affect her memory, other than, you know, like everybody's got high blood pressure and things like that?
She testified that she did not have any memory conditions, but she also had difficulty physically responding to plaintiff's counsel's questions from the United Kingdom. You know, she appeared for deposition in good faith. She testified truthfully. She stated specifically that she admitted to living at the address that was listed on the attestation of service on the date of the alleged service. She did not at any point testify specifically contrary to her declaration that she did in fact receive service. Counsel was questioning her regarding what she ate for breakfast in 2018, what the weather was like in 2018. As I sit here today, I don't know that. I would say probably that you don't know that as well. But for one
okay,
thing,
but if she signed a declaration that said that she was not served, and in fact she was served, which or she doesn't even know whether she was served, then how could she sign the declaration?
Well, she doesn't recall what she did on that particular day. However, she did testify that in specific what the process would be for allowing someone up to her unit via a buzz or a notice and a camera in her unit that would show someone outside. She also testified that she would never let anyone inside her unit without looking at the camera after receiving a buzz. She stated that she did not recall letting anyone unknown up to her unit on that particular day. She also provided various other places she could have been, including she was still treating from her medical conditions she suffered in Florida upon her return. And she also indicated she's involved in several charities where she could have also been. So this is nearly 2.5 years after the incident that she filed this, based on what she had informed us, despite counsel's representations that somehow TIF had some role to play in this. Ms. Hutchinson lives with her daughter. There was no action taken by either Ms. Hutchinson or her daughter on receiving this legal document. Nothing on the docket that says that they replied to the complaint after the complaint was filed. So she just, you know, because she doesn't recall specifically what she did 2.5 years earlier, doesn't necessarily mean that she directly contradicted her testimony and her declaration by saying that she did get served. She never said she got served. She just doesn't recall what happened on that day, but we would argue that's different than specifically letting an unknown individual up to her unit, which she said specifically she did not recall doing. Again, while she doesn't, you know, she didn't testify she had any specific memory issues. she doesn't, she's 80 years or nearly 80 years old. And she just didn't recall what happened on that particular day, but she did testify she did not recall letting anyone unknown up to her unit. So, basically, counsel's arguing that this elderly woman who's ill put in some kind of scheme to deliberately defraud the court. That's not the case. It says that she was served. We looked at the docket and saw that we informed her. She said she was not served. We filled out the declaration. She signed it. And she didn't recall what she ate for breakfast, what the weather was like on that particular day.
I heard you the first time you said that. Okay. So have I had a hearing yet on whether or not service has been proper? I don't think so.
No, ma'am. And we're in the process of getting that scheduled. But
yeah.
May I make one comment?
Because this may be an issue more, and I could reserve on this until after that hearing, but this may be more of an issue of, the weight that the court's going to give certain testimony and whether or not there's a preponderance that service was in fact affected. So,
ma'am, if I may, one thing that you said actually is absolutely correct about the me.
Oh, good. I like being correct.
Well, it jarred something in my memory.
Okay.
About me asking her what she recalled on the date she signed the declaration. The defendants waited almost 2.5 years to file this declaration after the date this woman was served. The declaration was filed, I believe, in late January of 2021. My deposition was taken roughly 1.5 months after that. For them to wait 2.5 years to file this, where she clearly states that she was not served, and then for me to be able to take her deposition 1.5 months after, where she clearly states she doesn't recall whether she was served. Temporarily, the time lag between the filing of the declaration and the taking of her deposition demonstrates that declaration is a falsehood.
Well, here's the thing. I am not comfortable striking her pleadings or assessing attorney's fees at this time. I would like to reserve ruling and readdress it when we have an evidentiary hearing on the issue of service, because I'd like to be able to consider all of it together. If she's going to testify, great. If she's not going to testify, then I'll review her transcript, the transcript of her deposition, as well as the declaration and any other evidence that you guys want to present to me, and I'll make a determination on whether she was properly served or not. And if she was properly served, and if at that time I find that in fact it does appear that she executed a declaration either intentionally setting forth the falsehood or just didn't actually know but executed it anyways, then I can address this at that time. But I'm not willing to do that right now.
All right, thank you, ma'am.
Yeah. So can you get me an order that essentially just continues this until the evidentiary hearing on the issue of service on her?
Will do.
All right. And then you guys are going to need to schedule it. If you want me, I try very hard to prep for my cases so that I don't have to reserve ruling, because when I do that, I've got about 5 reserved rulings that have been sitting around for weeks now because I can't get to them. So if when you set this, if you send me to my office, I will review these transcripts and affidavits before the hearing so that hopefully I'm prepared to make a ruling. I would prefer to do it that way if at all possible. I'm happy to have the hearing, but my point is that if you give me some sort of alert, like a memorandum or something like that, or if there's anything in the file you want me to look at legitimately, I will do that before the hearing. All right?
Your Honor, one last note. We've offered to settle this so we don't have to waste any more of the court's time by proceeding to file an answer on behalf of Ms. Hutchinson and accept jurisdiction. But unfortunately, that has not been agreed to by opposing counsel. So I just wanted to note that for the record. Okay, well, okay. So then if you're not, that would seem to say to me that perhaps having a hearing, an evidentiary hearing on this issue is not going to happen if they're going to file an answer. So I'm not really sure. We agreed to file the answer if plaintiff would just move on from this and we could move forward on the merits, but plaintiff's counsel has not agreed to that and wants to proceed on this motion. Okay, well, I am not in the role that I'm wearing today is not of mediator. If you guys want to mediate it, knock yourself out. But this is what I can do. This is what I can do.
On that point, this would be a great case for mediation. We have a lot of things going on. It might be a good point to try to send us to mediation.
Do you want me to send the whole case to mediation or just the one with regard to Ms. Hutchinson?
Well, the whole case would be the easier way to handle it because.
Okay, where are we in terms of service? And I know we have service, or allegedly have service on Ms. Hutchinson, but it seems like we knocked a few people out. Am I recalling correctly?
Of them,
Your Honor, if I may, I'm going to be filing an amended complaint that's going to clear up a lot of those issues.
Okay. I don't have a problem ordering this case to mediation. I just want to make sure of who it's governing and give everybody enough time to do that. So if I give you 60 days to mediate this case, is that sufficient time? I mean, I'm going to do it anyways. So the only question is are you going to mediate it sooner or later? So you are going to go to mediation. And if your trial is going to be longer than 5 days, you'll also be ordered to arbitration. So I don't have a problem ordering mediation within 60 days if that gives you enough time to do it.
I don't see why it would not, but I can certainly discuss that with
Mr. Okay, so get me an order on the mediation. And I've already told you what my order is on this case, but if things change, then you can send me a stipulated order on something else. All right?
Will do. Thank you, ma'am.
All right, thank you, counsel. All right, next case is Sikowski versus Tower Hill, 20 CA 2755. I think this is the next case. Yep, that's the next case. So that's what everybody else is here for?
No, ma'am, we're here for the state of good.
Hold on, did I miss that case? Yes, I did. Sorry. Let me go back because the one I just called is a long hearing. This is the estate of good, and this is a motion for attorney's fees. Mr. Stewart, you're here representing who?
Yes, ma'am. This is my motion, and good morning. This is my petition to pay the attorney's fees of Mr. Dan Capes and Mr. Keith Wickington and myself for the period of June 1st to 2020, almost a year ago, to December 31st, 2020. Mr. Wickington provided general litigation services of approximately $18,000. I have attorney's fees representing myself against a lawsuit against the estate of Rex Good, in which they settled and paid us $150,000. My fees in that matter are a little over $8,000. This includes my services as the curator from June to December of last year, an approximate amount of $23,000. And then Mr. Capes assisted the estate through doing the estate administration, and his fees for a little less than $9,000. Judge, I filed this petition in January of this year and immediately asked Mr. Lilly and his team if, number one, if they would stipulate to the fees, and then secondly, if they would not stipulate to the fees, whether they would require an evidentiary hearing. And if they wanted an evidentiary hearing, I requested that they tell me what specific entries gave them concern so that we could address them. I followed that up with an email on February 18th, another email on March 12th. Patty sent emails on March 19th, 25th, March 30th, and on April 8th, in which she stated, Mr. Lilly and Mr. Ganonis, as you're aware, we have a 15-minute Zoom hearing with Judge Krier on April 29th for the hearing of our fee motion filed January 27th, copy attached. Note this, and this is all in caps, bold, not set as an evidentiary hearing. Per Mr. Stewart's inquiry, we would like to know if you're willing to if you're going to require an evidentiary hearing on the matter. If you are opposing the motion, we need to obtain more time for the hearing to allow the evidence being put in. If you are willing to agree to our fees, please consider the attached stipulation proposed order. In the event that there are any specific entries, charges, etc., that you are concerned with, please advise and Mr. Stewart can address each of your concerns. We've heard nothing since January. So here we are 4 months later, and it's been almost a year since Mr. Capes, Mr. Keith and myself were paid. Just yesterday, I received an objection claiming, one, that we should have to wait until after the appeal is over. You may recall denying Ms. Price's attorney's fee claim to be reimbursed by Mr. Lilly's clients for her prevailing in the underlying estate case. And of course, she's been paid. She's trying to get fees back from the estate. Myself and my two counsel have not been paid at all. They also claim that I'm impartial because I've now appeared on behalf of Mr. Ganung as a personal representative. Well, they're correct. That's true. But I'm representing Mr. Ganung as personal representative on the same case I was representing myself, which was the defense of a claim for reimbursement by Mr. Lilly's client. So that shouldn't disqualify me for getting my fees. My suggestion, Judge, is that we continue this hearing. You order Mr. Lilly and his team to identify any specific entries in my bill that they think are incorrect or improper, and I'll address those. I would also ask that you authorize the payment of any entries that they do not dispute, and I will work with them to try and resolve, whatever problems they have. And since they've not raised any objections to Mr. Cape's fees or Keith's fees, then I think it's appropriate for the court to order that those fees be paid. Thank you very much, Judge.
All right. Excuse me, Mr. Lilly, go ahead.
Your Honor, I think that Mr. Dodano was going to speak first, and then I was going to give my perspective. Despite Mr. Stewart's suggestions, I only represent one of the parties.
Mm-hmm.
If Mr. Dodano may speak.
Yep. Go ahead.
Thank you, Your Honor. So I want to try to learn from our last.
Just for the record, identify who you're representing.
Sure. So Drew Dodano on behalf of Michael Good, Andrew Good, and Susan Knott as individuals.
Yep.
So I want to avoid the getting into the ugliness of the entitlement issue on these fees simply by trying to learn from our last hearing on the very same lines, where Your Honor decided that we shouldn't try to have evidentiary hearings on entitlement and reasonableness of these fees that are statutorily authorized prior to a resolution of the appeal, because we're only creating duplicative work if that appeal comes back down.
Yeah, but the situation with Mr. Capes and Mr. Keith is slightly different than that. I mean, that's not exactly the same thing. Yeah.
You're entirely correct, Your Honor. And I think the way that it's different is more significant and lends itself more towards waiting until the appeal is resolved. Excuse me. The reason is, whereas the attorney for the personal representative's fees coming under the statute, we're not going to have any dispute as to the propriety of those fees. If an attorney represents a personal representative or a proposed personal representative in a will contest, they're entitled to their fees. That's not a question. In this instance, as you may have seen from our joint objection, we would be objecting to entitlement, and we would want to get evidence through discovery of exactly when Mr. Janung became a client of Mr. Stewart's. But all of the analysis of all of those issues are, as I said, they're ugly, and we can, when the appeal is done, the ugliness may still be there, but the standing and the stakes for my clients in this matter will be gone. And I would very much rather not spend a significant amount of time trying to discover and litigating the issue of any potential impropriety here, if, as we think, it will not be necessary ultimately.
Mr. Stewart, review for me, because surprisingly enough, this is not the only ugly will contest that I have, to use Mr. Dodano's description. Review for me how Mr. Capes got involved and yourself got involved in this case.
Yes, ma'am. I was appointed as the curator by the court sometime ago.
That's what I thought. And then Mr. Capes was appointed as the PR.
No, ma'am. Mr. Capes, I retained to do the estate administration.
Oh, that's right.
I was the curator until Your Honor decided who the personal representative would be.
Okay.
Mr. Ganung, who was with us, was then appointed as the personal representative. I have filed my final.
So Mr. Capes, you filed your final report. Mr. Capes, the administration, his work is essentially over, right?
No, ma'am. He is continuing to work with Mr. Ganung himself.
Oh, I got you.
To complete the estate. The estate has not been completed, and it can't be pending this issue on appeal. And Judge, I would add that the fees that
Okay, well, here's the thing. First of all, Mr. Donato, I'm not going to not pay people that the court has appointed. Now, in terms of Mr. Capes's fees going forward and doing work for Mr. Janung, okay, maybe we have a separate discussion about that or a separate hearing about that. But in terms of not paying people that the court has appointed, I can't do that.
If I may, Your Honor,
may I?
Okay, I mean, I can do that, but I won't do that.
Well, let me just address a couple of potential ways that you would do that. If the court appointed a curator under the guise of being a neutral, independent administrator, only to find out 2 years later that they in fact were not neutral whatsoever, with record evidence of that lack of neutrality, then I would feel that the court would not only want to not pay them for that improper work, but potentially sanction them depending on the level of improperness here. It's really significant. All of the petitions.
Okay, but Mr. Dodano, as a curator, you're under the same obligations, and especially attorneys are under even a heightened level of operation under the law. I mean, first of all, they're not operating as a judge or a special magistrate, but they have certain fiduciary responsibilities as governed by law. Unless you're seeing, I mean, bias is not even an issue. That's not an issue because you're a PR. He's essentially a PR. And as a PR and or curator or a mini PR, he has to act in the best interest of the estate. That's his responsibility. I just don't see why this is relevant other than you guys don't want to pay the fees.
No, Your Honor, that's why it's relevant. We don't want to pay the fees, but we're not even potentially stakeholders pending this appeal. But more importantly, we have to pay curators and the attorneys, but like you said, they're acting as fiduciaries. If the curator is acting as a fiduciary on behalf of the estate, but also acting as attorney or has an attorney-client relationship with one of the will contestants, how can he then effectively have?
Because Mr. Dodano, attorneys do it every day. A trust and estates attorney do it every day of the week. That's how they operate. You come in, you get your estate plan, you meet with the attorney, the husband and the wife and the kids and so on and so forth. And guess what? That attorney is very often appointed as PR and or representing the estate. So again, I do not see that this is a problem.
Judge, there's a vehicle.
But this is in a case where we.
Judge, there's a vehicle for counsel to raise his concerns with my performance, and that is the petition for discharge includes an extensive accounting. And what he can do is he can say, we want to surcharge Mr. Stewart, we want to do this, we want to do that. The fees we're talking about here were from almost a year ago, before this lawsuit, in which if that's what his concern is, where I'm representing myself and defending against this $94,000 claim for estate reimbursements. And now I'm representing Mr. Ganung. That didn't even occur when these fees were incurred. And so.
Okay. Well, first of all.
May I speak?
Yeah, go ahead.
Your Honor, on behalf of the estate of Walter Good, I believe that the proposal that Mr. Stewart is making is not an inappropriate proposal. And I want to make sure that I'm clear about that for part of what I want to say in response. But I also want to be clear on this record. While I recognize what Your Honor is saying to Mr. Dodano in response to his arguments, the history of the appointment is not what Your Honor is assuming, and recognizing that Your Honor did not make the appointment or preside over the hearing of the appointment. The court was very clear on the record and in the order that this appointment was for impartiality as a placeholder. And so what is happening here, and when Mr. Stewart recites the events of the last 90 days roughly, and he suggests that I'm the only one, or Mr. Gionis, my law partner, the only ones who should have been responding, we were saying back to him and to his staff that he needed to coordinate with Mr. Dodano as well as us, and that while we were working on trying to work those types of issues out, those needed to happen. And we set up multiple good faith conferences because there are multiple issues at play, not just this motion here today. And in many of those respects, some of them didn't actually happen because of Mr. Stewart's unavailability or not appearing at the good faith conference. But in those discussions, it started to become obvious to us that Mr. Stewart has had a long-standing intention to take over as a counsel, and
Okay.
that is what gave rise.
But again, okay, this is again, you didn't raise this issue, and again, I was probably not the judge that appointed these folks, but nevertheless, a court did. And if you had that type of an issue, A, it should have been raised then. B, it should have been raised at the first opportunity that you had some type of a concern about this. And number three, as Mr. Stewart has pointed out, bias is not the issue here. Did he do something wrong? Are you looking at his report and saying, oh, he gave money to so-and-so that he shouldn't have given money to? I mean, really, that's what we're talking about. It's not some nefarious plot that the court is somehow going to punish somebody for. You know, this is all about numbers. I just don't see why we're having, and also, quite frankly, gentlemen, I mean, you waited 4 months to have this discussion here in front of me. That's ridiculous.
That's not correct, Your Honor, because this suggestion only came of record in the last few weeks. That appearance is brand new.
What appearance?
The appearance that Mr. Stewart has filed in the cases, in multiple cases, on behalf of a party when he was ordered to be a curator in an impartial position. He's now, as you would respectfully.
Okay, but as a curator, you have to file lawsuits sometimes.
No, Your Honor, that's not the issue. The issue isn't whether the curator.
Well, first of all, you're going to have to schedule this for a longer hearing because we only have 15 minutes. We've already used it up. So, first of all, my order is Mr. Capes gets paid.
And Mr. Wickington?
And Mr. Wickington. Up until the point in time that they started working for Mr. Janung as the PR, but I don't think that's at issue.
No, it's not, because this is through December 31st, and I don't think you appointed Mr. Janung until sometime in 2021.
All right, Mr. Stewart's fees, I'll have to have a longer evidentiary hearing, but just remember that what I'm looking at is show me on his report what he did wrong. You know, what did he do wrong as a curator? Curator isn't necessarily impartial because they're representing the estate. So as long as he represented the estate, and if he didn't, it would be putting his bar license at issue. So these are pretty serious allegations to be throwing around. So,
Your Honor, I want to be clear on the record. There are not serious allegations being thrown around or impropriety as to a bar issue.
If what you are saying, Mr. Lilly, is that Mr. Stewart did not properly represent the estate as an attorney because he is an attorney, that has certain, licensure type of ramifications.
Your Honor, I do not want to put that on a record, and I certainly am not making that allegation against Mr. Stewart, and I want that to be absolutely clear on this record. The issue that we have raised, and we've been very careful in the briefing of it, is that the way in which this appointment order was formed and the manner in which the appointment occurred over objection put impartiality on the face. That's the issue. We're not suggesting conflict of interest in an ethical sense. We're talking about exceeding the scope of the court's appointment. And the scope of the appointment is based on the order.
You can't have a PR or a curator that's unbiased. They have to be biased towards their client, which is the estate.
Judge.
So as long as he acted in the best interest of the estate, then I don't see what the problem is. And if he didn't, again, despite whatever a court does, that puts his licensure at issue. So, I mean, I'm not the Bar Association, so, but again, these are serious allegations. So you're going to have to reset the issues about Mr. Stewart for a longer and an evidentiary hearing. With regard to Mr. Capes or Mr. Wickington, they get paid. So I'll need an order from you, Mr. Stewart, after you circulated it to my office email address.
Judge, may I include a provision in the order that requires them to identify the entries in the timesheets that I have submitted in which they have a problem. I'm not asking Your Honor to get me paid for the rest of it. You know, it's going to be a year out before I get
Well,
paid.
I don't think I can do that, Mr. Stewart, quite frankly, because their issues are not, it does not sound to me as though their issues are with regard to reasonableness of the fees. They have a broader issue that I think they want to address.
Okay.
Your Honor, may
Yeah.
I just ask for the date of the order, or I'm sorry, for the date of the evidentiary hearing? The whole point that I was trying to make is that we will potentially not even be stakeholders in this case by the time that we could have that hearing.
Well,
So
I'm
rather
sorry,
than have a long drawn out hearing,
I'm not going to appoint people. A court cannot appoint people and not pay them. So we are going to address this, and the timing is not going to be connected with the appeal.
Is this hearing going to be just on a claim of my impartiality, or is it going to be that plus a fee hearing where I have to go through the,
I think, well, let's do entitlement first, and then we'll deal with fees. And then at that point in time, Mr. Stewart, if I rule that you're entitled to your fees, then I will order them to raise whatever specific objections they have to the reasonableness of your fees.
Okay, entitlement doesn't sound like it's going to take that long. Maybe.
Well, I don't know. You guys talk about it amongst yourselves.
All right.
Call my office for some time.
Okay.
All right.
All right.
I need to get on to the next case.
Thank you, Your Honor.
Thank you.
Thank you.
All right, next case is Skowanowski versus Tower Hill, 20 CA 2755. Who's here for the plaintiff? Anybody? Wow, we lost everybody. Huh. Kathy, do you know anything about that? Defendant's motion to abate. Kathy, can you hear me? Hello?
Okay, I gotcha.
Okay.
No, we didn't do that one.
I know. It's the last case on the docket, and
But I also had Massey Construction.
no, they came off. We already did that case. We already addressed this motion on Tuesday, I think. On Tuesday, yeah.
All right, so that was the only thing I had.
So, but you don't have a cancellation on Skowanowski, huh?
No.
Oh, I guess I could have let them talk longer then. Okay. All right, so just put it down as a no-show.
Okay.